The Dakota Proclamation by Meredith Quinn, Musa, page 125, section titled Treason. American citizens can commit the act of treason against the United States government, while Indians cannot. This cannot be attributed to the government. Choctaw and Chickasaw Nations versus U.S. 34, CT 17, reversed U.S. versus Choctaw Nation. Now, the question of citizenship for the Indian has a new meaning, something the Indian can do that the non-Indian can't. Therefore, the Indian must be a citizen of a country against which the United States government cannot charge this act. But why? At this point, most Indians become lost in legal confusion because no attorney has properly explained sovereignty rights according to the international law. Why? It is pretty well known that there are certain statutes that protect Indians, but attorneys practicing law under the guidelines of the United States can have their licenses revoked if they try to use them without the permission of the Secretary of the Interior, the President, or the Congress. Did you know that certain statutes can also create a charge of treason against attorneys if they use them? Statutes which would also protect the Indian. But why can't an Indian commit treason? Because the sovereignty rights of Indian nations are held in trust by the federal government. These rights include with them all the rights of a nation such as England, France, Spain, USA, or Cuba, to make war or charge persons that try to overthrow Indian nations with treason. Now, by treaty, the government is to protect the Indian nations and punish anyone that is attempting to overthrow them. When you look at the lands lost and the reservations that are no longer in existence, treason becomes the weapon that made this possible. Or was it genocide? Treason or genocide both work for the same goal: the destroying of a race, language, nation, and a culture. Both become intellectual murder, one the concept and the other the act. Before the question, can the Indians commit treason, can be asked, the answer to another question must be answered. Did the United States government commit the act of treason against the Indian nations, whose sovereignty rights were being held in trust to be protected by the U.S. as long as rivers flow to the sea and grass grows green? Were they protected or destroyed? What diplomat, president, or dictator can answer this question? So the Indian has a problem that only he can answer. Let me list some of the acts that are classified as treason. 1. Rebellion or insurrection against the Indian nations. 2. Seditious conspiracy against Indian nations. 3. Advocating overthrow of Indian governments. 4. Registration of certain organizations. 5. Activities affecting armed or police forces generally. 6. Activities affecting armed or police forces during wars. 7. Recruiting for services against Indian nations. 8. enlistment to service against Indian nations. 9. Giving aid and comfort to persons, Indian or non-Indian, committing these crimes. An Indian working for government agencies is committing the act of treason against Indian nations. Even the whole educational system of the United States could be charged with treason because what they're teaching is contributing to the act of overthrowing or destroying these Indian nations. So the next time you see a police officer entering Indian territory or land in dispute between the United States and members of Indian nations, this is an act of treason. How do most countries treat such persons? Let's go back to mentioning the 3 classes of physical beings: persons, inhabitants, and savages. Person was the one protected by the Constitution. He had to be white. The inhabitant came from the treaties of Guadalupe Hidalgo, Louisiana, and Florida. And of course, savages are members of Indian nations having treaties with the United States, who defeated the whites. The statement was made that all Mexican Americans, Latin or Spanish surnamed, Mongolians, Chinese, and Negroes were not legal citizens of the United States. Who is a citizen? The question should be, what is a citizen? Legally, a citizen is a person that has all the protection and rights of the Constitution of the United States, which is backed by the armed forces. When a legal citizen travels abroad, this country goes through a great deal to protect him. But for minorities, there is no protection. We must fight to stay alive and keep at protection from wiping us out. If this happened to a white man, he would know something was wrong and steps would be taken to correct the situation. But for non-white groups, it is hard getting minds and thinking together. We all want to be great, but we have no standards for the foundation of it. Whether you disagree with me or not, the problems are real. Nothing is going to change till you learn to act in a manner that will let the white man know you are no longer ignorant of these situations. You can't run. So far, there has never been any answers to the problems of the minorities which were put together by the white man. The only correct explanation to them printed so far is this one by an Indian. Maybe it will never be read because most minorities do not accept facts till a white person writes them and tells everyone to do the same. Now, when we non-whites assume that we are legal citizens of the United States, claiming to have all the protection that is promised by the Constitution of the United States, and when we test the courts of the land in this assumption, we are shocked at the results. Everybody cries that the white man does not keep his word, that his is a racist nation, that he is oppressing the poor. The black man says that his leaders are being killed, and the law is doing it. Mexican Americans can prove by records year after year that their women are raped, their community leaders are shot down, and investigations are outside the procedures of judicial systems of court protocol. The Puerto Rican, Peruvian, Hawaiian, and other dark-skinned people are all coming up with injustices. They claim that the white man's world is illegally kept from them. Even the Japanese were placed in concentration camps during World War II and had their property confiscated. This act can still be enforced any time the government feels it is in danger. All these complaints are legal acts the United States can enforce at any time because they happen to be part of national policy. I personally had read them several times, but paid no attention to them because I believed the intellectuals of these groups were working on them, and I had an Indian problem that took up all my time. These facts were presented to some Chicano friends one day, and they couldn't even understand them. After studying them for a while, they asked me to present them to their intellectual groups. Their intellectual groups, it seems, can't even begin to see how they worked legally against them. Outside of a small band of Mexican Americans in San Diego, calling themselves Toltecas of Aztlan, this knowledge is slowly being absorbed into their minds. They are coming back to being Indian, which I always say will open one's mind. By federal statutes, the government and their members have the right to do any of these acts to anyone outside of European or European bloodlines, legal acts that the governments of states can enforce on persons classified as inhabitants of ceded or conquered territories. Tell me that such a classification would have personal or civil human rights. Hold on to your seatbelts. There have never been civil human rights or constitution presented to the bodies of civilized nations so that dark-skinned people outside of white European can become members. No matter how you look at it, the civilized nations of the world were meant for white people only. According to international law, the only way that non-whites can gain these rights would be for the colored peoples to go to war against the white race and win. It's as simple as that. Nothing is going to change this concept, so all the problems of non-whites are going to continue. What really gets me mad is that the Indian, being the only race that has defeated the white race in battle, must now write this constitution and citizenship for these people while they sit around and argue over if it's a true fact. You would think that the burdens of the Indians were enough. No, he's got to think of all mankind. Why does the Indian have to pose a question that can only mean total war or peace for the world? But let's not get into the whole world just yet. Let's go through these federal statutes first. They're going to have to field day on me again. The left-winged element will call me an opportunist. The right-winged element will call me a left-winger because I'm writing about the government with a conspiracy. The liberals will say I'm an isolationist because I won't let them be the authority of the Indian problem. Maybe this time they'll charge the arrangement. I'm neither a right or left-winger, tail feather or head plume. I am an Indian. But let's get back to the statement that any Mexican American, Latin American, Spanish surname, Mongolian, or Chinese is not a legal citizen of the United States. The exception is the Indian, because at some future date, citizenship and constitution may be presented for approval by Congress, in which the non-white people is to be united with the Constitution and the Union of the United States. This has never been done. This is for people classified as inhabitants under the treaties of Louisiana, Florida, and Guadalupe Hidalgo. It's important that you understand this, because if you don't, you'll never know where your human rights are. Now, one just has to understand what he reads. Authorities and scholars of the world, let a dumb Indian straighten you out, so you won't get caught writing stupid books and teach class studies that mislead too many people. Treaty of Guadalupe Hidalgo, Article 8. This article speaks of two types of Mexicans, one that is established and the one that is not. both have property. The established, white, if they remained in ceded territory, would become citizens after 1 year. But not established would have their property respected, but at the end of 1 year, they would have to choose between being an immigrant of Mexico or an Indian. This is why we have Mexicans instead of Americans. Article 9 was changed in ratifications and replaced and reworded, which reads as follows: The Mexicans who in the territories aforesaid shall not preserve the character of citizens of the Mexican Republic, conformably with what is stipulated in the preceding article, shall be incorporated into the Union of the United States and be admitted at the proper time to be judged of by the Congress of the United States, according to the principles of the Constitution, and in the meantime shall be maintained and protected in the free enjoyment of their liberty and property, and secured in the free exercise of their religion without restriction. Looks good, right? What everybody fails to notice is that the preceding article was removed in the ratification. Article 10 was crossed out. Don't get hung up yet. There are 2 other documents that go with the treaty: the Protocol and the Proclamation. The Protocol first states, the American government, by suppressing the 19th article of the Treaty of Guadalupe Hidalgo and substituting the 3rd article of the Treaty of Louisiana, did not intend to diminish in any way what was agreed upon by the aforesaid Article 19th in favor of the inhabitants of the territories ceded by Mexico. Now let's review what we have learned so far. In Article 8, the Mexican that was established became a citizen after 1 year. The not established Mexicans would have property rights, and by federal statutes be given the choice of either being called Indians or immigrants of Mexico. Article 9 and 10 become important because they spoke of a preceding article, and that article was dropped. What it means is that the not established Mexican now has to preserve his character as a Mexican. He would someday present constitution and citizenship requesting to be united to the Union of the United States. This request would be judged by the Congress, which has never been done. In the meantime, they were to be protected as inhabitants in a ceded territory, same as the peoples of the territories of Louisiana and Florida. The Indians of the United States have already tried to get the citizenship. It was found that it had not been written, and it could not embrace Indians. The secret. Now we are ready to put together the secret of the white man. Persons. According to the manifest destiny, those known as human beings are white civilized. He is European or European descent, holds the right to discovery to this part of the world, asserted and acknowledged by all other European nations. That discovery followed by actual possession gave title. The legal citizens of the United States are European or European descent, protected by the Constitution. Inhabitants. Physical beings other than European or European descent found in the territory ceded by the treaties of Florida, Guadalupe, Hidalgo, and Louisiana. Inhabitants, Article 11, Paragraph 2, Article 9, will have citizenship and constitution like the United States at a future date to be approved by Congress. Savage, not persons, not inhabitants. Savages, Treaty of Guadalupe Hidalgo, Article 11, Paragraph 1, having treaties with the United States, who hold in trust all rights of sovereignty because of defeating the European. The word Indian or savage given by Europeans claiming the right of discovery to this part of the world. It can't say it plainer than that. In fact, there is legal proof that outside of everyone of European bloodlines is under guardianship, that people outside of white are not capable of handling their own affairs. Even if a white man were to try to help an Indian in his fight for Indian land rights, he would be classified as an incompetent. The government uses the right to be called a competent witness as a good means to hide statutes that govern non-white races. It's almost perfect the way it is done. Even the Japanese, who think they are out of it, are classified in such a way that it appears they are almost citizens of the United States instead of inhabitants. Sometimes one has to stop and understand the way non-white people are educated in institutions of higher learning, to understand that all civil rights acts passed by the United States Congress are for persons not protected by the Constitution automatically tells you that there is a question about citizenship. A whole world that was planned for white people only. You say, no civilized nation in the whole world would do such a thing. It's barbaric. Only a crazy nation of people would do such a thing. They would have to be mad. Nobody would tell such a lie, not even the president or the Supreme Court. My minister down the street, if this was the truth, would have said so. He swears on the Bible. He's a man of God. The Pope just sprinkled some water out of the courtyard, and he can't lie. My rabbi stuck his finger up the asshole of an animal, blessed it, and he can't lie. My India holy man just took a toke of black primo hash, and he can't lie. My pastor says white is good and black is evil, and he can't lie. My university professor just said that we were civilized. He's white, and he can't lie. What the hell is the truth? I'm sure glad to be only a dumb savage, not having to work out such complex and technical problems. I'm satisfied to be born Indian. That way I can die an Indian. The only thing I can get out of it is that if you are white, civilized, in lightness, can toke black primo hash, stick your finger up the asshole of an animal, sprinkle water or swear on the Bible, you've got it made. I'm lost. Let's get some idea of what citizenship laws do for a person and how the nation must protect him. It is in the rights of citizenship to a nation that human beings have laws written to govern their obligations to protect, participate, or perform duties that give notice, which bring in unity concepts to where laws are recognized as one government. It isolates itself from other countries. This citizenship also has benefits that raise its members intellectually and that protects the name and honor of its nation and banner. It protects things such as accumulated facts to be taught in sciences of education, health, welfare, census, industrial, and science occupations. But it also has laws that review the obligations that are not met by members of this citizenship. This is called order. One faces duty or the lack of it, and citizenship can question, disagree, disallow, disband, or discipline correction alone. If a citizen member breaks one of these laws of citizenship of this nation, punishment is due and correct. But if a member of the human race cannot have the rights to the citizenship of this nation, there can be no obligation, because without this obligation, this member cannot break the laws of this citizenship. It is at this point that I must disagree with the conclusions of one Judge J. Dundy, April 18, 1879, who stated that anyone that is a human being, whether a member of citizenship or not, must be punished for a crime. First, it covers the fact that there are human beings that have no rights in the countries of the world. Second, it covers the fact that there are countries that have no rights to be heard by other countries of the world. Under this concept, the white man has abused Aboriginal civil rights, which were won fairly by defeating the white race. This is true according to international law, which is the law of the white race. This same law or concept prevents the Indian, brown, black, or yellow man from receiving justice in his favor. They have no citizenship rights, yet the white law can detain and abuse, convict on due process, and leave obligations out. Then slavery is still a privilege of the white man. The same judge in the habeas corpus writ gave a prerequisite for the Indian to become an instant legal citizen of the United States by being dead. Yet the judge was not a citizen of that Indian nation. Still, our members are confused by assumptions. Mexican Americans say the Indian in Mexico is a citizen. True. The Indian in the United States is a citizen, but he has no civil or human rights because the European do not recognize his land rights, which is the situation in Mexico. So the Indian is a citizen of nothing. He is a citizen by a set of words, but the act itself cannot take a test of its own law, or the law of citizenship, for the Indian cannot protect itself. According to international law, he cannot belong to the civilized nations of the world. Half-breeds, a way to cause a war. So now we come to the time in history that the white man waited and watched 196 years ago. He knew that non-white races would piece together everything. Because in the past, the 12 other civilizations he built fell from power under the same concept. Read this concept carefully, because it's part of international law. How was the white man able to remove human rights from persons with dual and multiple nationalities when he, white himself, is that race and still remains free? He used color. He made this color two-color. He gave it intellectual existence by calling this a race of half-breeds. Since Bible beginnings, point of reference, there has been only one war between the first man, the red man, and the second man, the one without God, without color. The Mohawk Indians teach it in a story of a right and left-handed brother concept. The left-handed brother as the imitator. The Sioux teach that the brother that wanted to change his form. The only war there is, the one between the red man Indian and the white man, and the one between the godly and the ungodly. Now we know why the civilized nations were made for the colorless peoples, because the colored peoples, red, black, yellow, brown, have a secret that must be suppressed. When white men crossed the United States in their covered wagons with Bibles under their arms, they hunted, killed, and ate the Indians because he was classified as a lower type animal. The Indian has always known that the paleface could not tell the difference between animal and man. We are dealing with a man that can read, write, and speak an expression, yet expression is the language of God, Creator. When I hear the concept, let's make an Indian nation and call it Azatlan, I see the white man moving people because he has a problem. He will now use the peoples that have no citizenship or civil rights to defeat the other white nation moving to gain control of the world. So the half-breeds become the buffer zone to protect the one ideology along with the one law, international law. Both have the key to motivate the half-breed through the ideology. Let me show you how it was used only 87 years ago. There was a half-breed born in Canada that grew up and one day created Rupert's Land. This nation later became part of Canada, covering 2 million square miles. The province of Saskatchewan was part of that nation. His name was Louis Riel. He was half French and half Indian, identified by law as a Métis, a half-breed. He won the territory according to international law, yet because of his religion and language, he gave his allegiance to the French part of his identity. Because of this, he was moved into a class of human beings that had no citizenship or constitution. This is recognized by the white civilized nations of the world and by international law. He owed his allegiance to the two countries, side by side, which would not protect him. He could not be a legal citizen of either, but had to live and protect both. This term is called dual or multiple nationality. This was unknown to Louis Riel, who thought he had all the rights of the white man. Canada and the United States proved he had no rights as a human being. Because of his allegiance, the sovereignty of Indian also could not protect him. He was an inhabitant, and that only. He was hung for treason by Canada, and yet was a citizen of the United States. So both an American citizen and an inhabitant who has no rights can commit the act of treason. The Indian cannot, but the inhabitant can commit the act of treason, not only within the country he resides, but the bordering country near his place of residence. When I hear inhabitants talking of Aztlan and blacks talking of Republic of New Africa, separate from the United States, I say, be careful. It sounds like Rupert's Land. People who are not of European or European descent are in the exact legal position as this Métis was 87 years ago. Let me show you how the same situation existed before. I'll give you a comparative to both concepts and show how some countries hope to gain wealth off using the inhabitants' crusade for human rights. Louis Riel, because of religion and language, was in fact fighting for the French and didn't know it. James Wicks Taylor, using the dual and multiple citizenship of this Métis, tried to get the territory annexed to the United States. But Great Britain, weak in her territory, knew that the United States had to recognize international law and sovereign land rights, used this Métis leader to gain control of her territory. How she did this becomes one of the great examples showing that non-white persons can be placed in a position to work from both sides of their citizenship to gain control over masses by different countries. The leader, after being accepted by the Canadian government, led the territory of Rupert's Land and its members into a fight to stop white Canadian control over his territory, an act for which he was brought to trial and sentenced to hang by the neck till dead. He was charged with treason. The sentencing of this man was one of the greatest examples of non-citizenship, mostly because as an Indian, I'm acquainted with the problem. Louis Riel was brought to trial on Britain's 400-year-old Treason Act, going back to the days of King Edward III. High treason was to be tried in a court of full provincial judges, like the Supreme Court, with a 12-man jury. He was before a stipendiary magistrate, state or local area, with a 6-man jury, all white. Sound familiar? In the state of New Mexico, if you are caught speeding, the state police bring you before a person who has been assigned the job of finding and collecting your money and lets you go is very similar to this type of law judge. But the 6 counts of levying war against the Crown of England was the clue to Louis Rial's strange identity, that half-breeds had no citizenship rights or protection. The first 3 counts were based on Louis Rial, a subject of Our Lady the Queen. So Louis Rial was a citizen of Canada, but he also was a citizen of the United States. So he couldn't have been a subject of the Queen. It was found that he owed his natural allegiance to Britain, an illegitimate child. The last 3 counts were titled Living Within the Dominion of Canada and Under the Protection of the Queen. According to international law, because of dual and multiple nationalities, even though you are not a citizen or are an alien, you owe your local allegiance, in this case, to the Crown of England, confined child. So, according to international law, if you are born in the area and not of European or European descent, you are a citizen of both countries, in words only, and an alien to both. This is true because of natural, illegitimate, and local confined allegiance. If you are not white, civilized European or European descent and not a member of an Indian tribe, you could owe your allegiance to 3 and 4 countries in the area. Thereby, you help to perpetuate white civilized nations. The Negro fell into the inhabitants class by slavery. I don't know how the Mongolian, Chinese, or Japanese fell into it, but they're in it. The groundwork for the manifest destiny was laid out by England, where that only whites could belong to the civilized nations of the world, and she proved it. Even if she was weak by using the inhabitant, that person without citizenship rights, she was able to retain control over her territory by killing 1 inhabitant by law. She defeated the United States and France without firing 1 shot. Aztlan, the 5 southern states, or Rupert's Land. It's all the same. I see Spain, France, and Russia making their bid for the territory, using the inhabitant as the weapon and the law as the final judge. Better join the sovereign American Indian tribes for protection. Sovereignty won correctly, according to international law, is done by defeating the holder of the law. We're the only nation in the world today that say the civilized nations and world belong to all mankind. The black people of the South created a corporate state, which was named the Republic of New Africa, which was 100 years late in coming. The state of Mississippi shot up their headquarters and arrested them on the charge of treason. Now, if this was a citizen of the United States, this charge would have to come from the Supreme Court. But when a state charges a crime that is international in concept, it clearly shows that this person had no protection from the United States, which he was a subject to.